and can get benefit about it. Okay, so the sixth chapter is about the cyber security, and this is very conceptual chapter. There are the two important things that we will discuss. One is the interception and another is the blocking. And there are the two conflicting interests, the state interest on one side, state and societal interest, and individual interest on the other side. I think you all aware that there are the three interests in the jurisprudence classes: individual interest, societal interest, and the state interest. So the state interest is like the preservation of the state. State as in India should also be preserved, and that's why there are the provision of seditions, etc. कि state को injury ना हो, okay, sovereignty etc. उसको नुकसान ना हो. Now see, uh, I think 2 years back there was a news floating on the internet that there would be attack on the northeast people residing in Bangalore or the south of India. Okay, and after this news, what happened that the northeast people, when they received this news, when they got this news, they were scared and they start flying, some by buses, some by trains, and the the aeroplanes. So the basic idea is that the internet, or you can say this digital media, or you can say this virtual space, this technology has provided us, and it is boon for us, and it provided us the freedom to you know uh, uh, propagate our ideas. And by use of the information technology, we can very well exercise our freedom of speech and expression. But sometime this freedom of speech and expression, that is our individual interest, also sometime may cause the fear in the public. Similar fear may be if there is the news rumors कि दिल्ली पे तो अटैक होने वाला है पाकिस्तान से, so that will create law and order problem. So जो बेंगलोर वाला एग्जांपल था, आई थिंक आपने भी सुना होगा, सुना था कि नहीं आप लोगों ने, बेंगलोर में कि नॉर्थ ईस्ट के लोगों पे हमला होने वाला है, उसके बाद में सारे नॉर्थ ईस्ट वाले वहां से भागना शुरू कर दिए. हैव यू हर्ड दैट न्यूज 2-3 years बैक? सुना किसी ने? किसी ने नहीं सुना? यस गाइस, प्लीज आंसर. नीतू, अभय, प्रशांत.
नो सर, ऐसा सच कुछ याद नहीं है. मे बी सुना
अच्छा,
होगा पर अभी तक याद नहीं है.
ओके, ऐसा हुआ था, बट इट्स रियल न्यूज. ओके, एंड सो same thing maybe that there is a website that have the obscene material, there may be the pornographic material or very violent things that it's serving, and so it's necessary that the government have power of blocking. Now this is for the serving the societal as well as the sometimes state interest. अगर कोई स्टेट के अगेंस्ट सेडिशन या पूरा स्टेट के अगेंस्ट प्रोटेस्ट जब होते हैं, लाइक कश्मीर में इंटरनेट की सुविधा ब्लॉक कर देते हैं, बंद कर देते हैं, लाइक हांगकांग में चाइना ने सेम थिंग किया. ओके, द सेकंड इज इंटरसेप्शन. सो दिस इज ब्लॉकिंग. The second is interception. What is interception? Suppose there is one person sitting in India and another is sitting in Pakistan, beyond the border, and there is a conspiracy, the continuous talk is going, and we are celebrating, okay, that no one can intercept because it is the question of to individual privacy, or at least the privacy of the person who is in the India. So just to sometime to stop the crime, sometime for the investigation, the interception is also necessary. And so interception and blocking are important and necessary for the state. But there is the second thing, or the second side, or the you can say we have to balance it with the individual interest, that is the freedom of speech and expression. Whenever the government block any website, that means it's blocking the freedom of speech and expression. And the freedom of speech and expression, as given under Article 19(1)(a), it cannot be snatched unless the your action is protected by the Article 19(2). Okay. Similarly, the interception, because there is a privacy issue also, and in Puttaswamy judgment, the privacy is very sacred. In the WhatsApp conversation, it is one-to-one conversation. The message is decrypted, encrypted, then it is decrypted to the receiver, and so that in between the message cannot be read, and so authorities can get the access to the WhatsApp, that you have to show that what message actually been transferred from this number to this number. Now, how to balance these two interests, and that's the basic, functions, or would be the point of our discussion throughout this chapter in the cybersecurity. Here we will discuss section 69, 69A, 69B, 70, 70A, 70B. These four sections we will discuss, and whole our discussion on the chapter number 6 will be on the four category, or will be on the 4 point. The first point, that about the national security, or you can say the terminology that is used in section 69, or you can say in uh, larger thing, that what is interception, what is blocking, and when interception and blocking can be done. So the power is given to the central government or the state government, and that is not a blanket power. There are the rules framed accordingly. This power has to be exercised, otherwise the excess power will have the chilling effect on the freedom of speech and expression. The areas are defined, only in that case this power has to be used. These are the in interest of the sovereignty or integrity of India, same like in the Article 19 clause 2. The defense of India, security of state, friend relation with foreign state, public order, preventing an incitement to the commission of any cognizable offense relating to above, or for the investigation of the offense, there would be the power of interception and interception, monitoring, or decryption under section 69. Similarly, is about the blocking. Then comes to the procedure, and the procedure is very, very important for us. For that, the government has framed the rule. See, in every statute you will find the delegated legislation. What is delegated legislation? I think you have heard in the administrative law that lawmaking is the power of the legislative wing. In the center we have the parliament, at the state we have the state assembly. But lawmaking is not easy, and if the law has to be changed, it will take time. It has to go through that different proceeding, and so it's not easy to quickly change the provision, quickly replace the provision. Like 66A, this was held unconstitutional, but still the parliament has not enacted another provision in place of that. Otherwise, the Supreme Court has directed that maybe some of the terms in the section 66A are very good, and the new provision can be enacted, but that has not been done. And so what the thing is done, that the power by certain provision, like in the Information Technology Act, there is section 87, where the power is given to the central government. If the act is if the statute is the central statute, so power will be given to the central government, but sometime it to the state government also, to some limited extent. Like we have uh, Minerals Development Act, okay. And if it is state law, then through the lawmaking power, the delegated legislation power is to the, or you can say rule making power, to the state government. So here under the section 87, the central government can make the law. That is delegated legislation, and the rule is that the essential legislative function should not be delegated. So a framework has to be drawn, and after that the rule making power can be given. I think you have read Indre Delhi Lodge case also. Now the point is that section 69 that talk about interception monitoring, similarly blocking provision we have, there the rules are framed, and the rules are, the first is you will find in your Bayer Act, the information technology procedure and safeguard of interception monitoring and decryption of information rule 2009. This is the one rules, you will find many rules in it. The second is the information technology procedure and safeguard for blocking for access of information by the public rules 2009. And third is the information technology procedure and safeguard for monitoring and collecting the traffic data of information rule 2009. So these are the three body of rules that basically make the balance with respect to the state and societal interest with the individual interest. The third thing that we will discuss is this discussion with the this balancing or interface with the freedom of speech and expression and privacy uh, point. And the fourth one is right to be forgotten, that is still at the developing stage. See, all the material that present in the internet will also present even after 20 years if it has not been removed. And so any news, suppose a person A was framed in a case, so there was news this person was framed, even after that person get acquitted, usko saza nahi hui, then also the similar news will find in the internet, and this news always haunt that person. And so there is always debate that there should be right to be forgotten. Okay, there should be right to dealing. Even there is one case going on the Delhi High Court where the two businessmen, they argued that still the news related to their arrest and the involvement in the particular crime where they already has been acquitted by the court, still that news is on the internet, and many person, this news haunt them. You can see the example like Abhishek Manu Singhvi, and once there was one video uploaded of having in the compromising position with some women. Still, that is some newspaper said that still that is on the video, or maybe this news of husband of Silpa Shetty. So now he is booked under the that for the pornography, making of pornographic material. Maybe suppose if he is acquitted, I'm not predicting, I'm taking just example, but this news will still remain on that, all those things. And so this right of forgotten or right to delink, sometime the netizen, the person who use the net, they argue that there should be right to be forgotten, and this type of the things actually always haunt them, वो कभी पीछा नहीं छोड़ती. And there the Shreya Singhal versus Union of India, that case also we will discuss here. Just let me, yeah. Okay. Then there is Sriknath C. Nayyar versus developer of website, Kerala High Court 2008 criminal judgment. That site is given where you can find out this judgment. And Justice K.S. Puttuswamy, ये judgment तो मैंने आपको बता ही दिया. Then Anuradha Bhasin versus Union of India, that judgment also you can find out. So our discussion will be confined to this. So that means we will discuss four things. One is about the concept of interception and blocking. The second is about the procedural safeguard. The third is about the interface of the balance, or you can say conflicting interface interest, and the fourth one is right to forgotten. The provisions that we will discuss is from section 69 to section 70 clause B, and the rules related to blocking, rules relating to interception, rules relating to collection of traffic data enacted by the central government in 2009. So this would be our chapter 6. And generally question is asked from this chapter. Is very interesting and conceptual chapter. Many things we will connect it from the constitution also, this chapter. Okay. Uh, now come to the next part. Up to this chapter 6, provisions of the information technology, majority of the provision we will discuss. Now in part B basically is applicability of other law. So in the part B there are three chapters, chapter 7, 8 and 9, and these chapters are by under different law, but after coming of the information technology their dimension has been changed. Like the concept of the jurisdiction in the civil cases, it was there, but after the coming of the this information technology, the business has changed, the connotation of business has changed, the business area has changed. The earlier, before the internet, before the IT, a person if doing the business in the, if has the shop in the Delhi, the business area is in the Delhi. Now the person has its online website, so person from any area of the India can get the access and can get the product. So the area of business has changed. Similarly, the concept related to that business area means the jurisdiction has changed. Similarly, the IPR, trademark, etc. There also there is a change after the IT Act. So in the part B is basically the applicability of other laws, and that is that have changed after the advent of the information technology. We will discuss in these chapter 7, 8, 9. There would be the the provisions from the others law and very less provision from the IT law. Chapter 7, it's very small chapter, and many time question is not asked, but then also we cannot leave it because it's informative and important from other aspect. You can connect IT Act with the contract. See, the contract formation is not a new concept. We are from time immemorial we are making contract. Our day started with making of the contract. When you go for your breakfast and you purchase, ask from your shopkeeper the bread and the milk, that is the first time you make the contract after waking up. Then you go to the office, you enter into the metro, then there is another contract. So that means that there are many contracts that we every day we make, and this concept of contract making is not different. The law of the contract is also very very old. If we see that the statute that is prevalent in India is Indian Contract Act 1872, but that statute was enacted when the communication was through the letter. And so the communication of proposal, communication of acceptance, revocation, etc. was has to be done at that time with the letters. And so section 3, 4, 5, 6, etc. of the Indian Contract Act were according to that communication. Then the telephone was discovered. The contract formation was very spontaneous, and then Bhagwan Das Kedia case came, Supreme Court held the law. Now, after IT Act, IT advent, or after this information technology, contract are forming by various methods like emailing contract. And so here the first thing we will discuss under this chapter 7 is the formation of contract, the different kinds of the contract. One is the contract through email. Another may be the contract through app, like the through WhatsApp you are making the contract, through the web, on the web, going on a particular website and then order for something, that is another standard form. There are the app like the Flipkart, Amazon. There is the inventory, that is invitation to offer. Then you make the proposal, offer to invitation to offer, then you make the proposal, then company accept it, and then it became the contract. Okay, when proposal is accepted, then it cannot be revoked. So before acceptance of the proposal, revocation is possible. And in this case, in these cases, the time, it's the fraction of second it done. You make the proposal and same time you get the message, okay, we it has been done. Okay, and so the earlier law that applicable there is not possible. Just to find out the communication, etc., that is also not the place of the contract. for the jurisdiction if there would be the breach in the future. So what would be the place of the contract? Again, the old law applicable in the Indian Contract Act would not be, because in the telephonic time when the Bhagwan Das Kedia case was happened, suppose the person A is in the from place Ahmedabad, person B is from the Delhi. So in that case, the where would be the contract concluded? That is different. But now suppose you are traveling in the air and you are using the phone, so that is also the movability is also there, and so the whole notion was changed in that area. So that we will discuss. Second is the formation of a contract and the provision of section 11, 12, and 13. That I think under the second chapter also we have discussed that uh, addressee, receiver, etc. The acknowledgement we will discuss. And then the third thing is United Nations Convention on the Use of Electronic Communication in International Contract made at the international level, 2005. These two, three things we will discuss, relatively very small chapter. And there is one important case that you can see, um, uh, that is, this World Wrestling Entertainment versus Resma collection. This case is provided in your case material on the page number 181. There is two other cases that just referred here, that also we will have discussion on those also. PR Transport Agency versus Union of India 2006 judgment, and another is Trimax International FJD versus Vedanta Aluminium Limited. Okay, email exchange between the parties regarding the mutual obligation, that also constitute the contract. So that is about our chapter 7. Then the chapter 8. Chapter 8 is basically about the intellectual property rights. So in the intellectual property rights, and now I think there are two paper of the intellectual property right, IPR 1 and IPR 2, you read in 2 semester. And there are various types of the intellectual property right. One of them is the trademark. So trademark is basically showing or it's earned by having the good practices of the trade. Now, this with respect to the trademark, the every business has its own unique website, the domain name. Okay, and here the domain name, how that domain name have the intellectual property value, what would be if some other person have the same domain name. Okay, and so this is the concept basically is of the intellectual property right, but because the domain name and it's applicable in information technology, that's why we are discussing here. Okay, so we will have the discussion of the domain name function, and the domain name also used as a trademark. Hmm. So that thing. And then if someone else use the same, that means infringement or passing off that marks. So here uh, the different thing, the cyber squatting, the keyword sale by the search engine, all these things that are very important for a business, and that also have some the value in the monetary term, that we will discuss. Okay, so uh, the keyword sale by the search engines, so that whenever you put that thing, uh, uh, that particular result will be shown on that search engine. Like in the Google, you put the DU, so definitely Delhi University will be shown. But there may be another things with respect to the DU. So all those aspect in the detail we will discuss. And then dispute resolution under ICA NN policy, etc. Here there is one important case, the Satyam Info Ways Limited versus Sifi Net Solution Private Limited. Okay, so this was the first case where, respect to the domain name, the question arises and finally decided by the Supreme Court in 2005. By the so this judgment, I think given here is of the Delhi High Court, but there is latest judgment also by the Supreme Court. Okay, so that yes, 2004. Yes, it is latest one. Then there is Aqua Minerals versus Pramod Barse 2001 judgment, that also we will discuss. This is also very relatively very small topic, and already I think you have the concept of the IPR, but certainly certain things we will discuss so that you will get the idea and understand the domain name and its relevance and how that has to be protected in information technology age. Now the last chapter is about the jurisdiction, and this is conceptual. Every time one question is asked on this particular topic, now the different areas that we will discuss about, that jurisdiction in the civil law and jurisdiction in the criminal law, both aspect, and these aspect has been changed its notion, or you can say its scope by the Information Technology Act. See the defamation, if we talk about the criminal law, it also has been changed its jurisdiction, many other things. Now the offense have no geographical boundaries. Okay, like the similar theft, etc. You can done by from having anywhere in the world, and so there is no geographical boundaries. So here we will discuss that how internet has uh, changed the concept of that national concept. I think in the criminal law under IPC you have read about the jurisdiction. In the CRPC also there are the provisions with respect to the jurisdiction where the case has to be filed, where it has been committed. In the civil law CPC, section 14, 15, 16, then section 20 talk about the jurisdiction. If the property dispute is respect to the property, so the place where the property is situated, etc. So the principles are there. So प्रॉपर्टी वाले इशू में तो प्रॉपर्टी इमूवेबल प्रॉपर्टी वो सेम इशू है, but with respect to the other dispute, uh, the certain things have changed. Applicability of the traditional rules of jurisdiction on the internet are not actually applicable. Then the rule of the private international law that we apply in case of the person from one country lives in another country. Then personal jurisdiction on the defendant, the cause of action under section 20 of the CPC, that we will discuss. Then the criminal jurisdiction section 177 to 179 of the CRPC, 186, 189, 189, 88, 189 also we will discuss. The concept of territorial jurisdiction, that you read under the public international law, also you have read under the section 3 of the IPC also, and section 1 clause 2 and section 75 of the information technology also make this act that it would be applicable even beyond the territory of the India. So all those things we will discuss. In light of that, there is very very important case. Many time the examiner has used the facts of this case and asked the problem. The banyan tree holding private limited versus Murli Krishna Reddy, Delhi Division Bench judgment of the 2009. So this judgment we will discuss. Then Super Cassette Industry Limited, we have already, I think we will discuss under the intermediary. So there is no need to discuss here. Then there is uh, other judgment, this PR Transport Agency versus Union of India. That World Wrestling Entertainment, I think that we would already be discussed under the chapter 7 under the E contract. वहाँ पे भी जो है jurisdiction का एक क्वेश्चन आता है. So that's why both these cases of uh, Super Cassettes Industries Limited and World Wrestling WWE versus Resma collection were written here also. Okay. Then there is another case of Impresso Entertainment and Hospitality Private Limited. This is latest one versus SD Hospitality. That case also we will discuss. and then Maktul Fida Hussain versus Rajkumar Pandey. Okay, see, only banyan tree holding limited case is given. There you will find a certain test, certain scale where the jurisdiction is determined. Other cases are not provided in your case material. But see this WWE versus Reshma collection you will find under the earlier chapter. Super cassette also you will find the earlier chapter. Other you can download it or you can find the case comment from the through the internet. Okay, as far as books are concerned, I think in our earlier discussion I have told that there are many books that we have prescribed. One is book written by Vakul Sharma and some Seema Sharma. Another book is written by a very eminent lawyer on the internet, the Pawan Duggal. So Pawan Duggal Cyber Law. That is good book because it is in the commentary form, section wise section. You will find the discussion. Another book, two three. There are two three other books like written by Kamat Nandan and Karnika Sheth, but there the area is defined, and then you will find the essay type of the writings. It's not by section by section. So it's your choice what to purchase. But my suggestion that you purchase the book written by Pawan Duggal, और उससे भी अगर कम है तो आप वकुल शर्मा तो एटलीस्ट परचेज आपको करना ही करना चाहिए. Three things you have to required for this particular subject. One is the case material that you can download from website, another is the bare act, and third one is the one book. Only that. Other we will discuss throughout the classes. Okay. So with this today class is over. Some reading also we have provided there. You know, इन द केस मटेरियल वो भी आप पढ़ सकते हो अगर किसी को ज़्यादा इंटरेस्ट हो तो, बिकॉज इट्स वेरी इंटरेस्टिंग. And meanwhile we will discuss certain other concept and issues relating to the cyber law, because my duty is to develop the interest in the students, so that if only some of you will uh, do the research in this area, want to do higher study in the information technology, so that would be much better for me. Okay, so with this today class is over. Any question with respect to the syllabus, case, etc., if you want to ask, please ask.
सर जो केस
Yes.
केसमेट में नहीं दिया हुआ है उस केस को कहाँ से देखें फिर से?
Yes. See, there are two things that you have to observe. Every student keep note of it. See, problem based question will be asked only from the case that are given in your case material. उसके अलावा कितनी भी रीडिंग, कितने भी हम केस और एक्सप्लेन कर दें, उनसे प्रॉब्लम बेस्ड क्वेश्चन उनसे नहीं आएगा कभी भी. क्वेश्चन प्रॉब्लम बेस आएगा जो आप लोगों को प्रोवाइड किया हुआ है. ये एक पॉलिसी है लॉ फैकल्टी की, वी ऑल फॉलो इट, and that's why it's my request to all the students that go through the cases that are provided in your case material. जो दिए हुए हैं ना, जो जो पेजेस पे दिए हुए हैं, जो अंदर लिखे हुए हैं, एडिटेड केस है, उनको सबको पढ़ना है. The other cases that are given, in some cases you will find the web link where you can click and you will get the judgment. To other, you take just copy that name of the case and write it on the Google Baba, it will give the result. So from there you can get. There are certain website, or you can say certain other platform where you can get the केस कमेंट. कई कई एनएलयू या कई कई बच्चे लोग ऐसे किए होते हैं, वहां से उस केस का छोटा कमेंट, क्योंकि जजमेंट काफी बड़ा होता है, तो उस केस में क्या क्या था, क्या पार्टी थी, क्या इश्यू था, वो मिल जाता है. सो दैट इज फॉर क्विक रीडिंग ऑफ दैट केस. सो ऐसे आप कर सकते हो. ओके भास्कर.
सर कुछ केस के जो लिंक दिए हुए हैं वो केसमेट में जो लिंक दिए हुए हैं वो लिंक काम भी नहीं कर रहा है. ऐसे 2-3 केस मैंने देखा था, लिंक काम नहीं कर रहा है.
कोई
और
बात
कुछ
नहीं, तो
में
क्या
और
बात.
कुछ में जो है कि
सुनिए,
साइटेशन तो
नहीं
दे दिया.
नहीं नहीं लिंक हो रहा है. अगर वो लिंक नहीं भी दिया हो रहा है, जस्ट पार्टी का नाम और वो करके आप गूगल पे करो, वो मिल जाएगा केस आपको। ठीक है। जो
सर आपकी
लिंक
आवाज
से
नहीं आ रही।
खुल नहीं रहा है, उसमें आप उसके नाम को कॉपी करके गूगल पे डालो, वो केस आपको मिल जाएगा। Okay, so with this
ओके
today
सर।
class is over, and from next class we will have discussion on our first chapter. And so it's your work to think about it, that why this act was enacted in 2000, पहले क्यों नहीं हुआ, उस समय क्या हुआ, एकदम से अर्जेंट क्या था, बिकॉज देर आर मेनी टाइप ऑफ द कंसिक्वेंस, आई थिंक यू ऑल हैव हर्ड वाइल इन एट्थ नाइन्थ क्लास, 1857 की क्रांति, 1857 revolt, and there were many region, and one of the you know that triggered the this 1857 revolt, क्या था वो बिल्कुल तत्कालिक कारण क्या था 1857 की क्रांति का, पता है किसी को? 1857 की जो क्रांति हुई उसका
सर
काफी
म्यूटनी के
सारे
लिए।
कारण थे। हाँ, 1857 की जो म्यूटिनी थी उसका तत्कालिक कारण क्या था? वो जो चर्बी वाले कारतूस थे ना,
वो तो उसके बुलेट बुलेट
उसके
बुलेट
कारण।
के लिए, कारतूस के लिए था मेन रूप से, कि गाय और सुअर की चर्बी मिलाया गया था।
हाँ, so that was the तत्कालिक कारण. So similarly, here the question is that the internet I think came in USA around 1960, है ना, ऐसे आया था ना, and then this technology was developing, and we in the India have enacted the law in the 2000. So what was the actual the that reason that India enacted that law in 2000? So the because in 1995 and then at the international level, there are some pressure, you can say, from the international community, there are some domestic pressure also, and so finally we enacted law. Then the salient feature, इसमें क्या क्या provisions है, क्या important things है, all these things we are going to discuss in our next chapter. पहले chapter में तो यही है ना, तो यही discuss करेंगे, आप लोग कुछ पढ़ के आइए. Okay guys, with this today class is over. Bye bye, see you. Yes, Bhaskar, you have some query?
सर एक क्वेश्चन था कि इसको हम लोग जैसे कंप्यूटर का डिफिनेशन हम इसमें देखे हैं, आईटी लॉ का जो कंप्यूटर का डिफिनेशन दिया हुआ है, और जो नॉर्मली टेक्निकल डिफिनेशन जो कंप्यूटर का है, वो दोनों में काफी
Word.
अंतर है। तो इसको हम लोग टेक्नोलॉजी की तरह से देखें या लीगल तरीके से, किस तरीके से पढ़ना
नहीं,
बेहतर रहेगा आईटी
लीगल.
लॉ को?
आपको टेक्नोलॉजी पे उस पे चीजें नहीं है, आपको लीगली देखना है. अगर हो सकता है लाइक लाइक द एप्पल का भी फोन होता है, लेकिन उसको लोग आईफोन कहते हैं ना, बट दैट इज मोबाइल फोन.
यस सर।
So similarly, there are different gadgets by which and through which we use the information technology. So all those gadgets are called or known as computer by this law. So we have to go through the legal definitions. Okay.
तो जो जो टेक्निकल डिफिनेशन है तब उसे साइड कर देना होगा।
Yes, that we have not to use in for the legal sense, and that's why
ओके,
that's
थैंक
the
यू सर।
purpose of the definition. I think that why they in every statute you have one whole provisions that have only definitions. उसका क्या purpose होता है? Because the definition actually determine the scope of your legislation, कि उसका कितना area होगा. If the word has not been defined, so lawyer may stretch it into any extent and may compress it. And just to make the law clear, the word has to be defined. And in every statute, you will find one provision where there is the definition. Indian Constitution is also a legal document. It is also the like the one act or statute. So वहाँ पे भी एक definition clause है. But because it was the fundamental document, so वहाँ पे हमने वो काफ़ी fancy है ना, नया नया घर बनाते हैं, तो वो वहाँ पे आगे ना रख के हमने उस पे पीछे रख दिया है. There is one provision with respect to the definition. I think section 366 या ऐसे कुछ, article 366 ऐसे कुछ है. ठीक है. So
तो सर जो बेसिक बेसिक डिफिनेशन जो है सर, जैसे कंप्यूटर का जो टेक्नोलॉजिकल टर्म है, तो वो टेक्नोलॉजी से रिलेटेड टर्म है। अगर उसको अलग तरह से डिफाइंड किया गया है, जिसको कि डिराइव डेफिनेशन कह सकते हैं, तो वो बेसिक फीचर से तो अलग हो जाएगा। तो फिर उसको लिंक कैसे किया जाएगा? और
No,
कई सारे ऐसे
you are
जैसे हम
not
टर्म
accurate.
देखे हैं।
You are actually see. the definition that has been given is for the purpose. Like the Hindu Marriage Act. And what is the definition of the Hindu there? The,
Except
Hin-
for all
the,
are Hindu.
the Hindu means the Jain, Sikh, and Christian. So, would you
Ex-
think that it would dilute the religious freedom given under the Constitution? That is for only the purpose of that act. So, the definition given here is the purpose of the IT law. It's not that they are saying that this will be the definition will apply for the techno word. Okay, are you getting?
yes, sir.
Yeah. So that's the thing. We have to
Okay, thank
go
you, sir.
through. Okay, go through the legal things because the definition is for the statute only. Okay. So with this, bye bye. See you and good luck. I think tomorrow is holiday now.
Yes, sir.
So we will meet on Monday. Bye bye. See you.
Bye.
Thank you, sir.
Thank you, sir.